Welcome back. Here we have an update on that breaking news we've been following since the early morning hours here on Fox Local San Francisco. We are waiting to hear from key players in the case of a Los Gatos woman alleged to have hosted parties described by prosecutors in Santa Clara County as alcohol-soaked benders, in which teens as young as 14 were given alcohol and pressured to have sex. Shannon O'Connor has just been found guilty of most of the 20 felony and 43 misdemeanor counts she was facing, resulting from the alleged activity that's said to have started back at the height of COVID lockdowns, mid-2020. It's said to have gone on for at least a year or so. O'Connor was arrested and has been held without bail since October of 2021. The case itself started 4 months ago. She is expected to face jail time. We don't yet know how long that might be. So our Jesse Gary is still in court. He's been bringing us updates as the jury has been returning the verdict count by count. He also was able now to hear from the mother of one of the alleged victims. According to Jesse, this woman said, "You never know who you're having tea with across your dinner table. She is a predator. A mom can be a predator, a stalker, a groomer, and a harasser." The mother of a victim speaking to our Jesse Gary also made a note of saying that she is very thankful to the jurors who have just now finished returning their verdict. The jurors are one of the groups of people that we are hoping, perhaps expecting to hear from. Another live look outside here. You see KTVU Fox 2's microphone. They're front and center. We already know that the district attorney in this case, in this county, Jeff Rosen, has said that he will be speaking to reporters as soon as court lets out. I see a group of people walking out, and my eyesight's not great, so I can't tell if DA Rosen is among them, but let's just hang on this for one more minute in case it might be. But just so you know, we expect to hear from the DA, Jeff Rosen. We may or may not hear from jurors who made this decision, and of course we're going to bring in our own Jesse Gary as soon as he's able to get out of the courtroom. So this is not Jeff Rosen, but let's see if he is someone from the court, might be making a quick announcement that'll guide us in our coverage. Let's listen in.
Good afternoon, everybody. My name is Stephen Prikoski. I am the appointed counsel for Shannon Marie O'Connor. We are still mid-trial. As I think all of you understand, we just got a very, what I would characterize as a disappointing verdict. We got about 48 decisions from the jury. About 4 of them were favorable to Ms. O'Connor. I appreciate the jury's diligent efforts in this case. They were not exactly well, it's obviously not the result we were hoping for. They were also not, the not guilties that we achieved were not the not guilties that we in particular argued for as our highest priority. So we were obviously disappointed. I'm going to keep my comments relatively limited at this point because we are still in trial. We have a bifurcated trial this afternoon. That's essentially a separate trial on what we call the aggravated counts, or the aggravating factors in the case. The district attorney has to plead and prove all aggravators in the case. They have to do with criminal sophistication and particular vulnerability of the victims. The point of the aggravators is that they would enable but not require the court to essentially max Ms. O'Connor out within the sentencing ranges. I don't want to get too technical or deep into the woods, but that's about all I'm going to say since we are still mid-trial, since I've got about an hour and a half to prepare the next part of the trial and some important responsibilities. And then after that, we still have yet to be sentenced. And so we've got a lot of work to do. I certainly don't want to say anything inflammatory to the sentencing authority that she will see later on tonight. So I think I'm going to wrap it up with that. Thank you, everyone.
Is she going to jail? Is she going to jail?
She's already in jail. What do you mean? Is she going to jail? She's been there for 5 years. What are you talking about?
What's the maximum charges that she might, or the maximum amount of time that she could face?
It depends. It depends on whether or not you consider the misdemeanors as something that could be assigned consecutive to the felonies or not. That would be unusual, right? My hope, my honest hope and expectation is that for all the misdemeanor convictions that she suffered, she would be given a concurrent 1-year sentence and credit for time served on those. It appears to me that the max on the felonies is something in the range of about 27 years. okay? And someone asked me to spell my last name. The last name is P like Paul, R-E-K-O-S as in Sam, K-I. P-R-E-K-O-S-K-I.
That's Stephen with PH.
Stephen with a PH, thank you for asking that. I appreciate that.
She was guilty finding on sexual penetration of a person while intoxicated.
Correct.
She was not the person who committed the act. Correct? Can you explain that to us?
The district attorney had what I called in my arguments sort of unusual, attenuated theories of guilt that had to do with my client not being the direct perpetrator of the sex acts in the case. She was charged alternatively as an aider and abettor, or as the employer of an innocent agent. An innocent agent's like a dupe. You know, like if I ask you to carry my attaché case to Colombia, and I tell you it's only got papers in it, and it turns out to have a kilo of cocaine, you are my innocent agent. So yes, your question recognizes that my client did not penetrate personally, did not sexually assault personally any of the children, and the district attorney employed, as I said, what I call attenuated theories of liability. Nonetheless, the jury convicted her of those. There were 4 of those counts. 2 of them were misdemeanor and 2 of them were felony.
Why was it so important for you to only focus on certain of the charges in your closing arguments in defense? And what does that say that they all ended up coming back in this case guilty?
Well, it says that I failed, right? That I failed to connect and convince the jury of those particular arguments. There are multiple reasons. Some of them are technical, having to do with the import of the strikeable allegations, right? We fought the strikes, for one thing. The strikes affect the percentage of time that the litigant has to serve in custody. The other thing is that we attacked a weak, attenuated theory of liability, right? On 4 of the 5 counts that were sex counts, as this gentleman just recognized with this question, my client was not the direct perpetrator. That's unusual, right? I've been doing this for about 28 years. I've never, ever done a trial where a sex offender was charged as an aider and abettor or was charged as the perpetrator via the use of an innocent agent theory. And I think it's clear. We told the jury that's why we went to trial on this case. We went to trial on this case not because we were trying to say that my client didn't contribute or provide any of this alcohol. And that's the answer to the second half of your question. The reason why we effectively conceded the bulk of this case in the opening statement and only fought some counts in a very general sense is because we thought that we would lose credibility with the jurors if we tried to present a defense that denied that my client provided alcohol. We think that what happened was a progression of the provision of alcohol. We think what actually happened was at the beginning, my client wasn't providing alcohol at all. And we think that in the beginning, there were multiple places where the children were going where alcohol was provided. What ended up happening, though, ultimately was because the path was so easy at the O'Connor household that those other locations were dispensed with and all the alcohol imbibement happened, or not all, but much of the alcohol imbibement happened at the O'Connor household. And so while we thought that the district attorney's theory, which was essentially all bad all the time, as bad as you could imagine it, wasn't entirely accurate, we didn't think that dying on the hill of Mrs. O'Connor didn't provide the alcohol at the first party, right? There was credible testimony about the first party that the children snuck the alcohol out of the liquor cabinet. My client didn't know anything about it. The district attorney quibbled with that, and that's fine. But as a tactical proposition, what we were faced with was standing in front of the jury and telling them that my client didn't provide the alcohol, and we didn't think that that was a smart thing to do. You know, we thought that, as I said, that was a credibility challenging position to take, and so we consistently identified the 5 counts in the beginning of the case that we thought we would defend, and the way that I explained it to the jury was specifically, we would defend these 5 counts specifically. Those had to do with the 4 sex counts and the 1 dissuading a witness count, which we thought failed with regard to the evidence. The jury obviously disagreed. And then the other counts that we fought, we described to the jury that we defended them more in a general sense, because there were the child endangerment counts had a contingency about them, right? They were serious if the jury found the victims to be in danger for their life and limb, essentially, and they were not as serious if the jury found that the children were not in danger for their life and limb. Essentially, great bodily injury is the phrase, the term of art. The jury agreed with us on 4 of those, right? Where the district attorney had charged in 4 separate incidences that the children were in danger of great bodily injury or death, where they followed our suggestion that, in fact, they were not in danger for great bodily injury or death. And while I appreciate that, as I said, it wasn't central to the 5 counts that we defended, and at the end of the day, it helps a little bit, but not a lot.
How was Ms. O'Connor feeling after this verdict came down? Did you say anything to you? Did you say anything to her?
She's crushed. She's very, very disappointed. I don't think I could say it any better than that. I'm not going to say what she said to me, but she said some things to me as the verdicts were progressing that made me understand that she was deeply disappointed in the decision.
Was it just one one that were the more serious and the lesser were both not guilty by your count?
Yes, there was. There was one. So you'll notice on the 4 not guilty verdicts, 3 of those 4, the jury convicted of the lesser. There was 1 count where they didn't. I don't know why.
Is that the driving at Los Gatos?
No, it was not. Thank you, everyone.
Listening in as we just heard from defense attorney Stephen Prokosky describing what he said was a failure when it came to achieving a favorable verdict for his client, Shannon O'Connor, the woman known as the Los Gatos Party Mom. Walking up here to the microphone, we see DA Jeff Rosen. We're about to hear him speak. We're going to stay on top of his comments and bring you continued coverage over on the Fox local app. Let's listen in here to the district attorney, Jeff Rosen, speaking after a largely favorable verdict for the prosecution.
After many years and many, many victims, today there was justice. It was a long wait. It was a long trial. There was a lot of hardship and pain and suffering. But with the jury's verdict today, there is now justice. Defendant Shannon O'Connor was convicted of more than 60 crimes against more than a dozen child victims from Los Gatos. Every child who testified, the jury convicted the defendant of a charge involving that child. The charges included child endangerment, annoying and molesting a child, dissuading witnesses from testifying, and facilitating the forcible sexual assault from one child on to another child. We expect as parents that we protect children, protect our children, protect other people's children. This defendant took advantage of children, manipulated children, hurt children emotionally, mentally, physically, and did that for her own perverse reasons. And today there's justice for what she had done. It's important to recognize the victims who testified and their families, their parents who supported them during this very difficult ordeal. This case does not happen if the children do not come forward and stop what this defendant was doing. Without the children, the conduct continues. So our first thanks and appreciation is for the child victims in this case who came forward. Secondly, this is a case that few law enforcement agencies other than the District Attorney's Office Bureau of Investigations could investigate. There were hundreds of individuals interviewed. There are terabytes worth of information. Phone calls, jail calls, videos, social media. And investigator Christina Hanks from the District Attorney's Bureau of Investigation was the lead investigator and brought all of this evidence together. Without her, this case doesn't happen. And then, also standing with me are three prosecutors on this case. This case began with Rebecca Wise, who's standing to my right, who did an enormous amount of work on this case. She's such a good prosecutor, I then promoted her, and we then handed this case to Joanna Lee and Morgan Willis. And they put together a powerful and compelling presentation to the jury in a trial that took months, 4 months to try this case, 63 counts, more than 20 witnesses testifying, just a tremendously complex case. And they put it together in a very strong and compelling way, which allowed the jury to come back with a verdict of more than 60 guilty counts, and the defendant looking at decades and decades in prison. Because of Joanna's efforts and Morgan's efforts, there's justice and there's accountability. With that, I'm happy to take a few questions.
Can you tell us how many years she could be facing at this point, given the guilty verdicts today?
So there's a sentencing hearing that's going to happen later this afternoon, which may affect a little bit on the margins, the number of years, but it's safe to say that we're talking about more than 30 years in prison, somewhere in that neighborhood.
Was all the victims underage?
The victims at the time that these crimes were committed were minors. And I think one thing, honestly, that Joanna and Morgan did that I thought was extremely compelling is they had photographs of the victims at the time that this defendant committed her crimes against them, and you could see they were children. And then she had a photo next to that of them as what they look like today, 6 years later. And so I think that really helps to capture the long-term effects of what the defendant did to the victims in this case.
Can you clarify what's happening when the jury comes back after lunch?
Yes. So actually what's going to happen after lunch is the defendant is going to decide whether to waive jury and have the judge decide the aggravating factors. So I think that's going to happen first. If the defendant waives a jury trial on the aggravating factors, then there'll be a court trial on the aggravating factors. And the aggravating factors, if the judge or jury finds them to be true, would add some additional amount of time. But I can say that we're looking at 30 years or more in terms of just the charges that she's been convicted of now.
Can you clarify the
1 second.
Of a victim while intoxicated, the guilty charge. Again, whether is she guilty of that act or more of a facilitator, just so we can be sure and clear about that.
Yeah, so she was found guilty of 2 counts of forcible. She was found guilty of 2 counts of digital penetration of an individual that was too intoxicated to consent. And she was found guilty as an aider and abettor, as a facilitator of those crimes. She encouraged, facilitated, and aided and abetted one child in sexually assaulting another child, and did that on 2 separate occasions with 2 separate victims.
Are those the counts that help the most weight in terms of adding to the sentencing or the time?
Those are the most serious counts. Those counts carry 3, 6, or 8 years in prison. Yeah.
Ask you about the aggravators then.
So there'll be a jury trial or a court trial, and the aggravating factors that will be argued about are whether the defendant violated a position of trust, took advantage of vulnerable victims, or used very sophisticated measures and manipulation to commit these crimes. Those are some of the aggravating factors that the prosecution and defense will be arguing about in front of either a jury or a judge.
And your position on that is what?
Our position is that those aggravating factors are present, and that's what we'll be arguing to a judge or a jury. We think that those factors are things that the defendant did, and they would increase the potential sentence.
I know we're talking about a criminal individual here at this point, but are there any lessons for parents of this? Either hosting parties or with kids who might be going to parties?
Look, I have 2 daughters that are adults now. It's not easy to be a parent. But I think that every parent has a strong instinct to protect their children and to protect other children. And what is so disturbing and wrong about this case is this defendant used children, took advantage of them, manipulated them for her own perverse sexual interests. And I would just tell parents to hug their children.
Are you able to respond to the criticism from Shannon O'Connor's team that she felt I'm being used as sort of a face to, hold people accountable for these crimes, but it's being overblown, that she feels that she was never going to face a fair trial, words from her own team, and also feels that these punishments and the charges were harsher, and that, hey, other parents are hosting these parties as well, and she feels that she was in a way thrown under the bus and used as an example. That's the concern from her side. I'm wondering if you can respond to that.
She's entitled to her feelings. We're grateful for the verdict.
Can you or your team clarify exactly what was read? Because there were times where certain counts were skipped over and not read, so it's kind of jumping around a little bit. Can you offer some, like a finite number of things that happened? Because it was kind of hard to keep track of during the reading.
Yes, what happened during the reading is on a couple of occasions, maybe 2 to 3 occasions, the defendant was found not guilty of one offense and then found guilty of a lesser included offense. And the lesser included offense was not next to that greater offense in terms numerically. So that's why it skipped around a little bit.
Jumps? Because it feels like some counts weren't read.
Yes, we were. I was sitting next to Assistant District Attorney James Gibbons Shapiro. You know, we had kind of a spreadsheet, and we were following along like during the verdict reading. So it skipped around a little bit because of the lesser includeds. So there were a few of those, but overall there were more than 60 guilty verdicts.
So that were not.
There were the total number of counts were 63 were found guilty. I think it was 61.
Yeah, I think that I think the total number is probably closer to 55, because there were some lesser counts that there was no verdict on because she was convicted of the Great Oakland.
Yeah, it is complicated. Sometimes I say things like dozens, but I understand that reporters want something more specific. So I think that the most specific we will be is she was convicted of more than 55 counts. She was found not guilty of anything on maybe 2 of those counts. Other than that, she was found guilty of lessers. And the reason that it doesn't add up to 63 is if she was convicted of the greater offense, then the lesser offense goes away.
There's a lot of evidence in this case about various use of social media, different platforms. Once the evidence did come out, to what extent do you feel like that did play a role in this case, one way or the other? What do you think this case says about, not maybe Snapchat specifically or Instagram specifically, which are of course extensively referenced in this case, but just in general what the evidence does show now when you look at this?
Well, I think the evidence in this case was quite strong because of a combination of dozens of victims and witnesses testifying. In addition, social media evidence. In addition, evidence of the defendant herself in terms of what she said and different conversations she had from the jail. And I think that's part of why this was such a strong and compelling case. Social media there's a huge debate in our country about the good and bad purposes of social media. Certainly this particular case, social media was a factor in the crimes that were committed and was not a positive in terms of this case. Now, from a prosecution perspective, it provided us a lot of evidence to convict her, but our goal in the DA's office is not that there should be a crime and then we convict someone. Really, our goal is for there not to be a crime in the first place. And so to the extent that social media facilitated this criminal activity, I think that's a very bad thing.
Can you weigh in on the sheer complexity? I mean, how many years has it been? 4, 5, 6 at this point?
6 years.
So many twists and turns. 2 sets of prosecutors as well that we've talked to for years. The defendant herself trying to speak out in this and that way, sometimes in the process, a lot of times out of the normal process of court, and then just where your office stands today. If you're able just to reflect on all that and of its perspective.
I am incredibly grateful that we have investigators and prosecutors that work in the DA's office that are as committed as they are. They're excellent, they're smart, but they're dedicated. And Investigator Hanks was dogged in this investigation and uncovered more and more criminal activity, more and more victims. And without her dedication, working with Rebecca Wise, we would not have found all of these victims, and we wouldn't have gotten the full measure of justice. If there's 15 victims, we want all 15 victims to be heard. To reflect the seriousness of the crime, every victim is important, and the defendant should be accountable for everything that she did. And then to, have one prosecutor and one investigator working diligently on this case for 4 or 5 years, and then bringing in a new team several months before the trial was very challenging for Miss Lee and Miss Willis. But I asked them to do it because I knew they would, and I knew they would do a great job. And that's what they did. They understood the seriousness of this case, the gravity of it, how important it is to our community, and they worked their asses off. And I think the jury verdict reflects their prosecutorial excellence. And I know that Rebecca and Investigator Hanks and Joanna and Morgan have had innumerable conversations with the victims and their families and keeping them updated about what's happening. And our office has a victim services team that has been in constant communication with the victims in this case. We never lose sight of the victims, and while we're focused on on winning in court and making sure the defendants held accountable. We're also incredibly focused on helping the victims heal and recover from this kind of violation and criminal activity that was committed against them. And we're just so profoundly grateful to the victims for coming forward and putting a stop to this. You know, the defendant manipulated them and used them and then tried to get them not to talk. And these children and their families were resolute and overcame that, and it's their resilience that led to this verdict.
How many victims were there and how many took the stand to testify? And can you just reiterate the resilience of you to do that?
In this case, there were more than a dozen, we think 15 victims, okay? But more than 20 children testified in this case. And I think that given that this crime happened in a small town in our county, everyone in Los Gatos is 1 degree separated from one of the victims or their families in this case. And I think while this is justice for the people of the state of California, I think that for the folks that live in Los Gatos,